It's a case that set the community on edge for more than 6 months. The Louisville woman shot multiple times in her own home as police executed a botched no-knock raid. Today, fire detective Brett Hankison was indicted on 3 counts of wanton endangerment in the first degree, saying he acted with extreme indifference to the value of human life. But it doesn't appear any of those counts are related to the homicide of Breonna Taylor herself. They're felonies, and if convicted, he could face 5 years in prison on each count. He was booked and released, $15,000 of bond paid.
We want full transparency. We want the truth. Breonna Taylor's death should not be swept under the rug in any way. Her life matters.
Officer Miles Cosgrove and Sergeant Jonathan Mattingly are accused of shooting into Taylor's apartment. They were found justified in their use of force. The state's attorney general says the FBI will continue to investigate potential violations of federal law in this case. Taking a look now live at downtown Louisville, where protesters have been ordered by police to leave downtown. They say the gathering is unlawful and have even threatened to use chemicals and make arrests if they don't leave. I spoke with criminal defense attorney and retired judge Charlie Baird about the decision today, and he had this to say. Judge Baird, let's begin with the warrant, a no-knock warrant. How common are these and why are they used?
A no-knock warrant is fairly common, and they're used because they think the circumstances under which the warrant will be executed could be threatening to the officer's safety. And so rather than knock on the front door and wait for somebody to come, the officers are allowed to just no-knock, essentially, and just knock the door down and go right on in the residence.
The charge brought against the officer in this case is wanton endangerment. Now, that doesn't mean or doesn't have anything really to do with Breonna Taylor's death, does it?
No, it does not, and that was quite surprising to me.
Why is that?
Well, because the circumstances of this case, of this young lady being in her own home, the home being, I think there were 6 officers, but being in her own home and being shot in her own home and obviously dying seems like it's a case that calls for more than just a wanton endangerment.
Let's talk about the officers. They were you mentioned, in the wrong place. What rights does a homeowner have when this kind of mistake is made?
Well, they certainly have a civil remedy, which means they could sue the governing authority over the police officers. And I think, in fact, they have done that. And I think that the civil suit has, in fact, been settled for like $12 million. But that's their remedy.
So in a civil case like that, what would they have to prove? That the officers were in the wrong?
They would have to prove that they would have to prove that the officers were negligent when they executed the warrant. And it seems like a strong case of negligence here when they execute the warrant on the wrong residence.
Finally, Judge, again, thanks for your time. As it pertains to the criminal investigation, is this the end or could there be other charges at some point in the future?
There can be other charges. The only thing that would limit other charges would be a statute of limitations. So if the investigation did not render more charges fairly quickly, then they may be unavailable. Those charges may be unavailable. And the other thing is there is no statute of limitations for murder. So a charge of murder could be brought against the officer currently charged or any other officer involved at some future date, or I should say at any future date.
I said finally, but I do have one more. This is obviously a pretty unique case in the way it was handled. Do you or have you seen cases like this where an initial charge was made and then further charges were brought in the future after that initial charge was made?
I have indeed seen that. It's not very often. Typically, a prosecutor will charge the offense, and then that will be the end of the charging process. And it very well may be in this case, because it looks to me like this event occurred, quite a while back, and the grand jury had investigated. So it could well be that their investigation is wrapped up.
Judge Charlie Baird, thank you so much for your expertise and your time here on KVUE this afternoon.
Thank you, Brian. Good talking to you.